Hey,
All
well,
right. Hi. Hi. This is Curt Farone,
and Brad Pinsky.
and we are here for our annual review of the top cases of 2024. Brad, go ahead.
Okay, well, so I picked five, as we normally do, and we're not going to go. I'm not going to go through all of them in detail, but I want to tell basically things I found interesting. One is we're starting in North Carolina, and this I forgot when this was. I think November-ish. But a medic failed a drug test. Maybe we just covered it in December. But he claimed he was lawfully prescribed the drugs,
Mhm.
but the drugs would remain in his system for 4 days. Doesn't mean he was impaired. It just remained in his system, and but he would test positive on a urine test for the drugs, and he was failing, right? So he was terminated for violating the no drug policy. So he's just sued. We don't have a court decision. But all the others I picked, I think, were just court decisions. But this one I found so interesting because it's about marijuana. Not in this case, but this is a marijuana issue because we don't have a test where you can determine impairment. And with a lot of if there's cocaine in your system, right? There's cocaine metabolites. Cocaine actually only stays in your system for about 5 minutes, the parent. So we don't know whether you're actually, impaired at the time you're tested. It just appears. Marijuana is the biggest issue of that. So I thought this was interesting for the facts, not right. And I can't wait to see the holding. I think the department ultimately could win, but the allegation here is that the department failed to engage in the accommodation discussion that you're supposed to have to accommodate disability. And I think people forget that. And that's a good highlight. When somebody says, I have a disability, A, maybe it's not even a disability, but B, okay, what problem does it cause and how can we accommodate it? And you've got to ask the question, and then I would document what you were asked to accommodate and how, and then if you have any other reasonable suggestions, what is a reasonable accommodation? Document that. And ultimately, if you can't accommodate as the employee wants you to, now you have a documentation that we've engaged in this process. If you skip that discussion, you're done. So those two things, I can see how you could accommodate this. On the other hand, all of this assumes your person's being honest. And that's the accommodation. I don't know how you accommodate.
Mhm.
Otherwise, anyone else can say, oh, I took it 4 days ago. So an all or nothing test, right? You either are totally clear or you're fired. I don't have a problem with that. So I ultimately think the department succeeds in there is no reasonable accommodation to offer, but but there's still an ADA violation just for not having the discussion. But as to the discrimination lawsuit, anyway, so that's what I thought was one of my top five because I think it's going to be a big marijuana issue. So the others are decisions that I have. And my next one went back to Tennessee, where we have a captain who lost his disability claim. He was an alcoholic, and he resigned, but he claimed that he was constructively terminated, right, and violated FMLA and ADA and all that. But here was the key part I thought was interesting. He never disclosed his diagnosis to his employer. So the court says by the time he disclosed it, which is so common, is when you were being terminated. You already did the act for which you were going to be terminated for. So the court says it can't be pretextual if the department didn't know about it. So if you don't have a disability that you told them about or that you're perceived as having, then how can you be discriminated against based on a disability the employer doesn't know about? So this happens all the time. I had this year. It hasn't resulted in a lawsuit because I said, provide us proof where we even could discriminate based on a disability. But that happens so often where somebody's like, oh, well, I have a disability. So what? Right? If you didn't tell us, if we should have known, who cares? So I thought the reason they lost in Tennessee was a very good right? Good decision.
Let me just interject because it reminded me of a case out of Indiana. It was about 5 years ago that I covered, and it was I forget if it was diabetes or a seizure case, female medic, but she was denying that she had a disability. She said, "I don't have a disability." Okay. And she told him repeatedly, "I don't have a disability. I'm fine. I should be allowed to work." And so she continued insisting she did not have a disability. Then she ended up getting fired and sued for disability discrimination. And the court said the fact that she denied having a disability doesn't eliminate your obligation to try to find a reasonable accommodation for her. So interesting, but.
And also think the fact that she's denying it must mean that they perceived it. The
Exactly.
Perceived it. So if you perceive it,
it's perception. Absolutely.
Right? Yeah. Okay. Next, this is so funny because I just had a discussion on this exact case about an hour ago. We're in the FDNY, and courts have held that. Well, I'll give you the facts, but they relieved the city of liability. The facts here were that a call came in, the city dispatcher took the call and determined it was a basic life support call. Very important aspect to this case. I'll get back to in a minute. They sent the BLS ambulance. The BLS ambulance gets there, finds an unresponsive patient, decides they want to wait for ALS. Clearly discretionary, presumably clearly discretionary. In New York, it would be. And they wait. The paramedics show they can't get intubated. They can't get the patient intubated. They decide, okay, now let's go to the hospital. Ultimately, we have a bad outcome, but we have the lawsuit against the city. And the city basically says, listen, when the court says that the city, when a municipality acts in a discretionary capacity, when it's not following a policy that would dictate the outcome, that generally the government, when it's performing government function like fire and EMS, cannot be liable for exercising discretion. You and I say that a million times in many different ways, depending what your state you're in, right? Some might call it, public officer immunity or, but public officer doctrine or public immunity doctrine. There's a lot of them. But I thought two things were interesting about this. One is it's nothing new, right? The law has always, at least in New York, been clear that when a government's fulfilling government function like ambulance and fire, and it acts in a discretionary capacity and makes a discretionary decision, as long as it wasn't blatantly the wrong decision and there was a basis, the city's protected.
I think New York's a little bit different there in that you require discretion. Most states use that public duty doctrine to just say you've got no duty. So you reach the same end, but the public duty doctrine, you don't have to prove discretion because you start playing with that discretion word. And I could say what foot I put in my bunker pants first is discretion because I've got to decide which one goes in first, which to me, discretion means major public policy decision making. I think that's, other than New York and a couple of other states, when people use the term discretion, they're talking about, should we buy a 95-foot aerial or 110-foot aerial?
Right.
Okay. That's, or should we put a fire station here or there?
But New York is how do we fight the fire, et cetera.
Right. So in New York, Maine, I'm licensed in Maine. Maine says when a firefighter or a police officer decides to turn on their lights or not is discretion.
Wow. Okay. So
you see what I'm saying? You get down. There was a case in Maine also, a prison guard. When the prison guard chose to close the door, close the cell door, was discretion.
So that gets me to my point, because this is either I'm wrong with what I'm about to say, and I'm sure there are viewers from the FDNY. Let me know. I know a ton of FDNY EMS people I could ask, but yeah, I'm either wrong or the attorneys didn't know to argue it. And so here's my point. I think that FDNY uses the EMD system, and in fact, the Clausen EMD system, which is not a discretionary system. It is a flow chart. And if this, then that, if this, then that, right? So if somebody says I'm having trouble breathing, then it's a Charlie call, et cetera. So if that was the case, then I would argue that following the EMD and dispatching BLS, not ALS, is not discretionary. And that may have been because the lawyers didn't know to raise that on either end. Or maybe they don't use.
You're really in the weeds of that. And that's where somebody's not a firefighter is not going to see that. Right. But
right.
Yeah.
So I just, so for that reason, I thought this case was interesting. It's nothing new saying, at least in New York, nothing new talking about discretion versus, following a policy. But it is when I think it brings to light. I wonder if all the attorneys missed the EMD issue.
Interesting. Anyway. I would have, honestly, I would have. And as soon as you said it, like light comes on. So.
It's I don't know, maybe it's just my world, I guess, right? We think of things that nobody else thinks about. Okay, so I got two more, I think. So I'm just going to stay in New York, where the FDNY firefighters, a ton of firefighters lost, and I can't say this word on YouTube, of course, but let's call it C-19, where the FDNY firefighters who refused to comply with the vaccine mandate in 2021 and were terminated, sued, and they lost. Now, this may be the end of all these suits. One pops up every so often, but this was such a big one. But they said, look, they accommodated when they could 100 other firefighters, or some small, very small percentage, but they refused to accommodate a few thousand requests. I bring it up because I think it's the end of these cases. I think I'm sure there's one or two pending out there somewhere. But I just thought it was interesting. The court held that the plaintiffs have a constitutionally protected property interest, right, in their job and their employment. But if you didn't comply with the requirement of the job, like getting a vaccine, you could be terminated. I'm curious today, if we knew what we knew today, would we make the same choices? I'm still so pissed off, as are many, that New York said thank you to our nurses. And by the way, you're all fired if you don't want to get a vaccine. All right. You worked without one in this new pandemic era. But now that we have a vaccine, use it or lose your job. And they fired a ton of nurses who are still on medical leave, by the way, and getting paid in some cases by the state. Anyway, I thought that was interesting, and goodbye to C-19, hopefully, as far as cases go with a mandatory vaccine.
Well, there was, while you're unless you're going to get to it, the Ninth Circuit case on that very C-19 issue that held that the city of Spokane, Washington, that allowed mutual aid to come in.
Right. Oh, that was a great case. I didn't think about that.
Yeah, so that's another, I think, important one. But.
Yeah, they said you weren't treating everybody the same. Obviously, you would allow mutual aid firefighters not to have it.
If it was so bad, if it was so serious that we have to fire you, then what are you doing allowing mutual aid to come in?
And in that case, didn't they say, great argument, but sorry, you still lose?
No.
Or they won.
Ninth Circuit sent it back to the district court. And said,
sent it back. Okay.
They sent it back to the district court, which... I mean, based on the guardrails that the Ninth Circuit put, there's only one way that they can rule here now. And I'm predicting some sort of a settlement. I can't believe they're going to fight it after that. But they're basically saying that, how serious can it be if you're allowing mutual aid? If it was truly that serious, think about something like maybe like Ebola, if it was contagious, more contagious, or that you would say you cannot be responding in our community without this, or
right.
So,
right.
Interesting.
But on the other hand, what can you control? I'm shocked as we now talk about that. I probably should have pulled that case instead. But I'm shocked that case, I probably made the same comments on the radio show. Because you can't control your mutual aid. It's mutual aid. You can't control.
Yeah, but if it's that, I think what the point of the argument is, if it was that damn serious, okay, that we can't employ you, then what are you doing bringing in mutual aid that doesn't adhere to the same thing?
Yeah.
In other words, I guess it's not all that important.
But for the fact that a very smart court and conservative court, the Ninth Circuit, said that, I would be like, there's no chance of winning. I would have taken the opposite view. I would have been wrong, a little egg on my face, but I'm okay. Okay, so now I want to go to Madison Fire Department. Is this Wisconsin, I think?
Madison.
So it says Madison's physical abilities test upheld by the Seventh Circuit. So seventh, I think, would be Wisconsin. Yep. So what was really interesting about this is there was a test, right? A CPAT test. They didn't use the IAFF test or IFC test or whatever one. They didn't use the test that most departments use. They created their own test, and a woman failed it and said, well, it's discriminatory. You should have used the other test. I took the other test. I passed the other test. And effectively, the court says, listen, this test was A, less discriminatory, but B, was reasonably related to what your specific department, which is the key why I want to point this out, to what your specific department requires. It's a better a predictor of success or failure in your specific department. And so often we have clients or viewers or whatever who don't really pay attention to essential job performance requirements, right? What's required of the job. And this case reflects what I constantly preach, which is when somebody says, what policies do we start working on? Like must-have policies or must-have policy service. And by the way, thank you to all our subscribers. And we look forward to welcoming new ones in the new year. But if you don't have one of the first policies we did, we will send you in our must-have policy service is a sample essential job performance requirements. If you don't have those, how can you do anything that's related to physical performance, whether it's testing, right? Physical endurance testing, whether it's disability determinations, can your disability be reasonably accommodated or not? How can you do that without essential job performance requirements? But this court then looks at this and says, it is okay to look at your specific job, how this test affects your department specifically, right? And that matters. And I'll end with this. The reason it matters is because, look, my department drafts. So I always laugh, and I've done this or joke, but in my department, you need to be able to climb a 5-foot ladder, put your hands over your head, if I could do this on video, pull out a 60-pound, 70-pound, large diameter, hard suction hose, right? But it's hard suction. And you have to pass it over your head and then do this awkward move and drop it down to the person behind you, hopefully wearing your helmet, not cracking your skull open. But that physical move for our department is an essential job function. For the FDNY, it may not be, right? They're not passing hard suction over their head necessarily. Yes, they do draft. I get it. But so essential job performance requirements are so important. And here their PAT specifically addresses what their department, right, requires. So it's a great move. Every department should very much focus on essential job performance requirements. And if you need help, you should sign up for must-have policies. Those are my 5, Curt. Let's see yours.
Well, I actually went a little bit further, and I'm not going to get into the detail that you did, okay, on mine. But I kind of broke up. I've got my you can't make this stuff up. I've got the most important, and then I've got settlements. I want to throw it out to you so you can kind of think about it, and you and the other folks. If you totaled up the top 10 settlements, let me see if I got them.
As an average or a total?
Total, yeah.
Oh, so add up all the highest settlements.
The top 10 settlements, what does the total come to? In terms of, you could say, what are the top 10 fire department settlements in 2024? What is the total?
Are we going to include Kobe Bryant here for 47 million? Because that's going to really throw us off.
Yeah, I don't think that one was in 2024. It was 2023.
Was it 23?
No, it's not listed in mine.
Okay, so maybe it was 23.
Yeah, so
because that would screw that. So do you want to guess, or are we going to hold off?
Hint, it won't make that big a difference. It's yeah. So all right.
Oh,
so
I would not have been anywhere. Okay.
Yeah, we'll come back. Let me do my most important, and we'll kind of go through them. The starting with number 5. I got a couple of runners up. But we'll get into the top 5. Number 1, the San Diego firefighters' recent lawsuit against the city, claiming that their refusal to produce certain HIPAA-protected and medical confidentiality-protected documents from the firefighters who are facing discipline, claiming that it's confidential or protected, that they don't have to produce it, alleging that violates the firefighters' procedural bill of rights. I think that's a really important case. We'll see how it comes out, but it sort of pits medical confidentiality against firefighter discipline and the ability of the accused firefighter to get information they need to prepare a defense. So that fascinates me. Next one is Kansas City. It would go back to the tragic vehicle accident, the triple fatal
The case that never went
apparatus accident.
away.
Yeah, and the firefighter ended up grieving his discipline and was basically, I guess, reinstated with like a 3-day suspension without pay. And so the city is challenging that. So I think that's just it could also be under you can't make this stuff up, but I think it's an important one because he was charged with manslaughter, vehicular manslaughter. He ended up basically admitting liability for $32 million in damages and so on. So next one, third on the list is a case out of both Arizona and Texas, but about the same time came down with a contrary decisions on time off for union officials, whether or not giving union officials time off with pay violates the gift clause. So Arizona said it did, Texas said it did not. Okay, so and you can go back, I forget when that was. It was in August. We talked about that one. I thought that was an interesting one. In the number 2 ranking is actually 3 different posts that we did related to OSHA. And the initial post was in February where OSHA said they are proposing to change the fire service regulations, basically the fire brigade standard. They're going to give it a new name and call it the emergency response standard. The next one was in March where they extended the deadline, and the last one was in September where they said we really need to go back and rethink this.
Because it may not apply well to volunteer fire departments.
Exactly. Yeah, that was the primary concern. So, bottom line, from what I understand, latest I was researching it last week. The latest it stands is their expected decision within the first quarter of 2025. We also have a new administration coming in that is anti-regulation. So it wouldn't surprise me if that goes nowhere. But at the same time, maybe it will. Maybe the issues are significant enough that it will get enacted. So, but at least for right now, it's off. And then what I think is one of the most important cases was, and I've spoken to the person involved in this case. Maybe that's why I'm a little biased on it, but it was the Connecticut PIO who was charged criminally.
Oh, yeah.
With taking pictures and then posting them on the fire department's Facebook page.
Reversed it.
He was right. They dismissed the charges, which they put this man through hell for 2 years for no reason. He did not violate that statute. Number one, the statute's ridiculous. Okay, it's absolutely ridiculous. We don't need a law like that. We're over criminalizing things, but they made it a criminal offense for someone to take pictures at emergency scenes. That's Connecticut. So that's sort of number one. The charges were dismissed because he really didn't do anything wrong. Now he is suing the police officers that were involved in arresting him, and he's suing them for false arrest and malicious prosecution. So good luck, Steve, on that one. And, hopefully the good guys will win that one. So those are my 5 most important. We'll lighten it up a little bit and we'll get into the top, we'll do the top 5 for, let me see here. I got to get my numbers squared away here, but top 5, you can't make this stuff up. First one was the St. Louis firefighter who stole a patient's wallet and credit card and then was caught on video using it. So he was caught stealing it on video and then using the credit card on video.
And you could have gone, I don't know if you did, right back to the FDNY where they did a sting on the person who was stealing it. I mean, I think we had 2 or 3, definitely 2, but maybe 3 of those credit card ones. But my favorite, frankly, was the one where they set the guy up because they knew they were going to do it. And so they set him up and the guy steals from the fake patient. So anyway.
Yeah, that was a Providence one. So, but the next one is Clarksburg, West Virginia, where the entire fire department, including the fire chief, filed an FLSA suit claiming that they hadn't been paid properly. Now, the chief was relatively new, so he was basically saying back when I was in the rank and file, I hadn't been paid overtime. So you have the entire fire department, everyone in the fire department joins this FLSA suit. The next thing that happens is the fire chief gets fired.
Yeah. No retaliation there.
So we've got, and that's not funny. I certainly don't mean to laugh at, at that situation. So, but next one is the firefighters in Ottawa, Canada, who were found not guilty for an alleged firehouse assault. And, you can go back and read the details of it. I'm glad I don't want to get into the details on that one either right now, but I think that the good guys won that one. But, they were charged criminally in what amounted to nothing more than the kind of horseplay that happens in every fire department I've ever known about or been involved in. And it's a ridiculous case that should have never been brought. It was political correctness going astray here that led to that. So next one is the firefighter, and I forget where it was. I got the link right here. I can go to it. But we had a firefighter, Troy, New York, who he was apparently on EMS, I guess, and he was burglarizing the homes of patients that he had transported to the hospital.
Because he knew they were gone, yeah.
Just, unbelievable. Okay.
Yet in New York State, we still don't have criminal background checks.
Yep.
I'm trying.
So let's see. I forget, I don't know how many that is, but the last couple here, there's two of them, and it has out of Kansas City, Missouri again. But we have a female firefighter that is alleging that she's been harassed. And we also had a male firefighter. Let me go get the details on this one, because this is truly, you can't make this stuff up. This guy allegedly urinated on her on her personal clothing and while she was off. And what the details are, I don't know, but there was just a bunch of different things that.
Yeah, she said she was treated by the entire department, right? If I recall correctly, that way, right? She heard rumors that her gear may have been urinated on. She heard, and so that part was a little weak, but if true.
No, and the Kansas City police collected the wet items in biohazard bags, packaged them for testing, and there was DNA that came from this particular firefighter who was, allegedly had shown some animosity toward her in the past. So it all sort of lined up. But yeah,
and that's a growing trend, though. I don't know if it's a growing trend, but it's a continuation of a trend of males not believing that women fit in the fire service, and it's a disturbing trend. We have 8% of the career fire service.
If it is a trend, but again, one of the things that I'm trying to study a little bit better is that really happening? Or are we having folks that any given percentage of the population are going to be difficult people, whether we call them toxic personalities or whatever it may be. But when and it's what we're talking about is depending on the data that you look at, you can look at different data, say anything, but let's, 1 out of 10, maybe 1 out of 100, but I think it's probably closer to 1 out of 10, difficult personality disorder, toxic personality, whatever you want to call it. But when that 1 out of 10 happens to be in a protected class, are they using that and how much of that is really, or the flip side of that is, do we have a toxic personality that is doing things like urinating on people's gear, right. And that they are affecting other people, they're bullying people, they're making people's work life a living hell to the point where they don't even feel comfortable coming to work. So, I think we've got toxic personalities at both ends of that. We've got toxic personalities that are claiming victim status. We've got toxic personalities that are perpetrating problems. And, how do we kind of sort through those two aspects of it? So,
and part of the answer is the chief. right? The chief, if you've got a chief, frankly, if I'm hiring a chief, I want to know, do you have issues with, right? Anybody, women, black, pick one, right? Do you have any issues? And of course, they're going to say no. But then at least the employer said, okay, well, I expect you, regardless of any feelings you have, to conduct this department in an open, fair, reasonable manner without hatred, bias, discriminatory acts. We've seen a lot of things like that, right? We saw the firefighter who was late, a female. She claimed she was probationary and being discriminated against. They put her turnout gear up the flagpole, right? I think that was a 23 one. And, we see these things. So sometimes the question is, are you treating someone the same as all other men? And maybe she's just more difficult or more sensitive to it. Not in the case of urinating on your gear, of course, right?
You can have two. If the numbers are correct, the numbers I gave you, 1 out of 10, right. Eventually 1 out of 10 perpetrators is going to be working with 1 out of 10 victims.
Yeah.
And now you've got a situation where somebody is a pain in the butt.
Yep.
They happen to be in a protected class, and you have a perpetrator who's, one of them. And now you put those two together, and you've got the recipe for "you can't make this stuff up" headline.
Yep, absolutely.
So, all right. So let's get to settlements. Okay. And I really can't believe the number that I'm going to give you. And truth be told, one of them is really what is driving this one. Okay. Take that one out. It's a little bit different. Okay.
Oh, can I guess?
Yeah, go ahead.
Okay. So if I had to guess, look, I personally think the average normal settlement, well, in real life, the average normal settlement is like $10,000, $30,000 some odd dollars. Right. But in these cases that we cover for discrimination, normally I recall seeing settlements of 100,000, et cetera. But, and that I think is the normal range, 100, 200,000. On the really bad ones, not the Kobe Bryant 40 million bads, but on the really bads, normally see 1.2. So, but for one of the comments you have made, I would have said that they would average, the top ones would have averaged about $1 million a piece. And I would have said, okay, let's call it $12 million for 10 different claims would have been my guess, but I'm guessing I'm way off.
Yeah, and it's because of one case or two cases in particular. I think if we took the top two cases off, we'd have a different number, okay? 1.5 billion.
Okay, so I missed it just by a billion.
Just a little bit, just by a billion. A billion,
400 million, right.
So here we go. The number 10. California Fire District settles an assault case for $965,000. So that's the smallest. Okay. Yeah. Then we've got Kansas City settles "you can't make this stuff up" harassment suit. Okay. 1.3 million. Okay. A third reverse discrimination suit in Kansas City, Missouri. Wow, they're getting up there. Like they're getting Casey Moe is getting numbers almost like FDNY, but 1.5 million. Okay. FDNY settles an FLSA overtime suit for 4.3 million.
Now, and there was a lot of people, right? There was a lot of people in there.
Oh yeah, sure. That was the fire inspectors.
Inspection.
Yeah. Sacramento settles a restraint death for 4.45 million. So that's number 6.
So, but 2 assault cases for a lot of money. Okay.
Number 5, Chicago contemplates $5 million settlement in mistaken DOA suit. So they thought somebody was dead, but they weren't.
Surprise. Dead. And usually they're only living another day or so after that, right? So,
right.
But okay.
Family of murdered LA County firefighter. This is the firehouse
captain
shooting,
who walked in the firehouse.
Right, received 7.2 million. Jacksonville firefighters in that ship fire. They settled. They got 16 million.
Yeah.
Okay. So now we're down to the last 2. This is a pretty big one. California utility settles with U.S. Forest Service over wildland fire for 80 million.
Oh, okay.
Okay, so that was a big one. And then the last one, Houston finally resolves wage dispute. Now, this has been going back 10 or 12, maybe longer.
I remember you gave them a big thumbs up for this.
Started with a parity problem with law enforcement, and they went to a referendum, and I've got a lot of friends down there in Houston. And but this one, $1.5 billion settlement.
Wow.
1.5 billion. So The total there, let me get the total settlements, top 10 settlements in the fire service. And I didn't have any judgments that came anywhere near this. So, but we're talking about 1.5 billion, 120 million. Yeah. Wow.
Yeah.
1,500,120,715.
And
Yeah.
and just so people understand, right? The big ones are about mostly employment issues with a
Mhm.
lot of people.
The first
Unless
one,
you
yeah.
right, yeah, unless you get like a strangling as these assaults. But I bet if we broke these out for discrimination, harassment, violence, and FLSA and work related, right? Obviously, you start seeing the difference in the amounts, but they're still big monies. Here's the scary part:
Mhm.
intentional acts are not covered by insurance.
Yeah.
Right. So you cannot insure a criminal act. You cannot insure a wage violation. You cannot. So all of these, most of those cases are paid out by the taxpayers, not by an insurance company who's been receiving premiums. So these are even worse than just when you think about how impactful they are. Now, obviously, the victims deserved what they got, right, and deserve their compensation. But yeah, wow.
Yeah.
So don't mess with FLSA and other things.
All right. Well, that's the annual review for 2024. I think this is our third annual review or second. I'm not sure.
It's at least a third. At least a third. I think it is. I think it is. So I think we're coming into our fourth year at some point.
All right. Well, thank you for all of our loyal subscribers. Again, I kind of mentioned this in our last session there, but we really appreciate the feedback and the support and you know.
And
So
hey, I just to forecast a couple of things coming up. So in which will be big, and we'll see how it goes. This is the hardest, but one of the most important cases of my life, at least. But we have the question of whether the federal Seventh Amendment right to a jury trial applies to the states, right? If in a civil case, so the as everyone should know, just paraphrasing this, right? There's a case. I've obtained a temporary restraining order stopping the state of New York from being able to prosecute a paramedic. And the argument I have is, listen, under the Seventh Amendment of the federal Constitution, as applied to the states through the 14th Amendment, which says you can't deprive anyone of life, liberty, or due process, or life, liberty without due process, or property in this case. But I said, the Seventh Amendment should apply to the states. Now there's 2,500 cases, and I'm not joking about that number. There's almost 3,000 cases that disagree with me. There are 3 cases that agree with me. But I think the world has turned. I think this U.S. Supreme Court, it's a new Supreme Court. And I thought based on some recent decisions, we could revisit that issue. I have a judge who's very open to discussing or listening to the issue. So my briefs are due in mid-January. My next few weeks will be hell. But I expect an oral argument, which is televised, will be televised, but comes up at the end of January. And then I suspect we're going to receive a very long, thoughtful, good decision, no matter how it works out. I'm impressed with this judge's attentiveness. But this is, if we win, though it will get appealed, and then that will get appealed, and then ultimately or may not go to the U.S. Supreme Court, but it will certainly go to the New York State's highest court, where far fewer than 0.5% of cases ever go. But nonetheless, this will be a big deal for everybody, because if the Seventh Amendment applies to the states, every firefighter in front of, or every EMT, anyone licensed by a state agency may now have the right to a jury trial and not to a hokey, administrative trial. So I have a ton of cases which we're getting decisions on in January and February and March, but no bigger one than this, because it could really have a nationwide effect.
Yeah, it goes beyond just EMS. It goes any time that there is some sort of an administrative process that doesn't give somebody a right to go before a jury, and it could impact someone's life, liberty, or property. That's going to be a problem. And so this has the potential to change things like the way OSHA issues citations and a whole bunch of other administrative type decisions. So
Yep, it's going to be very interesting. But you know, I have a 1 out of 2,500 chance of winning, I think.
I
But
think it's a little better than that, but
we'll
well,
see.
we're behind you. We're behind you. So, and we'll see how it all works out.
Thank you,
So,
thank you. Well, everybody, happy New Year, and we will see everybody next week.
yeah, see you on the other side in 2025. All right, Brad.
Take care,
Thank you.
everyone.